Today we're talking about directors' duties and various types of trouble directors can get in and what to do about it. So we're starting off with the basic tasks of the board, looking at the nature of the director's duties, what sort of the types of them you've got and how best to approach them. What you're meant to get from this session at least is the ability to identify broadly what the director's duties are about and to appreciate that there are some boundaries to the behavior of the board, and then that there's a link between the idea of corporate governance that we've been discussing and the idea of the duties. You know who this guy is? This guy was your typical rich boss of the 80s in the city walking around with a cigar. That is what used to happen. Now, why do we use this guy as an example? As a wonderful example of corporate mismanagement, he was characterized, for example, as not a person who can be relied on to exercise proper stewardship of a publicly quoted company. And this was the official opinion of the Department of Trade and Industry on his behavior. But what happened is that he took control of the newspaper group. These are the Mirror Group newspapers. He took control of the group that contained this newspaper. And what he did is he took complete control over its management and finances and kind of tried to restore the group to profitability because it was very badly at the time, losing a lot of money. He managed to do this. Early 90s was a good period for newspapers because this was the way in which people got the news. You didn't have the internet yet, you didn't have more devices, not a lot of people had computers at home, so journalism was basically press. And then you got a little TV, but you didn't have so many TV channels. Press was a big deal. So the guy took all that, took the group, did the restructuring, but the problem is he assumed all the power within the company and he kept it for himself. So he was completely in control of everything that was happening within there. The problem with this is that this works great if things are going well, okay? So you implement your restructuring and everybody's happy and it seems to be going well and you're making more money and there's kind of liquidity in the company, you can pay everything. However, when things are not going well, then you start getting into trouble. This guy personally was in charge of everything. He was in charge of all the money transfers, all the cash, all the accounts everywhere. And as the group started getting into trouble, the group had various newspapers in it, it has various media outlets. It also had a pension fund, because pension funds here are private and they're linked to the businesses. When he started running out of money, he started shifting money around from one business to the next within the group. Actually, he started sucking money out of the pension fund in order to fund existing obligations of the newspapers. Now, this is an idea because the pension fund is meant to be there and it's meant to be safe, and the funds are meant to be ring-fenced so they pay people's pensions in the future. So the pension fund is not your ad hoc savings account that you can go in and get money to finance the rest of your operations when you feel like it. Now, this led to a collapse of the business. The problem is, due to this severe mismanagement and all the mess created in there, not only the parts of the businesses that were not making money went into trouble, the whole thing went into trouble, and crucially, the pension fund got into trouble. This guy was accused of behaving in a highly unethical and socially irresponsible manner. He was described by a bully that many that worked with him. Even his wife hates him. You know, a lot of people realized that this guy had just completely gone rogue and did stuff of a criminal nature. The story ends with him turning up dead somewhere before he had the chance to account for the various nasty things. Why do we need to talk about this, and why is this a good example to everything else that we're doing? These guys are trouble. And the idea of an all-powerful executive that does whatever he wants with the company is not a safe arrangement. And I know that, as we've discussed, the shareholders have got this. So if the shareholders get wind of trouble, then they can kind of push the button and get rid of their board. Yes, they can do this, but the question is, what good is this if the mismanagement is so bad and went on for so long before anybody realized that the company is already bust? So it's not enough to say, if you ruin this, then we're going to come after you or we're going to get rid of you, when the aim is to keep the company alive and successful. So clearly you need some mechanisms that control the behavior of the people who are in charge or who are the board before they get into catastrophic problems that are not solvable. So this is like the difference between, I'm guessing, regulation and tort. Regulation that is imposed by the government is meant to prevent bad things from happening. The law of tort addresses the bad things once they've happened in order to compensate people. If you get kind of poisoned by, if you were poisoned by a drink you were having at the early 20th century, then you could sue them using the law of tort. But maybe you would prefer not to be poisoned to begin with. That's why you have consumer protection regulations in place at the moment. What became apparent here is that we need some sort of mechanism that directs the behavior of the board and prevents these types of abuses from occurring and prevents the idea of an all-powerful CEO that runs the show and leading the company into significant trouble. The way this has been approached is both by enhancing the corporate governance guidance that we've seen so far. So you get the UK Corporate Governance Code that tells those in charge of public listed corporations how they should behave, what is the best way to communicate, what is the best way to arrange operations, and if they fail to do that or if they choose not to do that, then they need to answer back to the shareholders in a direct sense, so the shareholders get advance warning of what's going on so they can choose to remove this board if they think that it's very dangerous. So that's one way. And the other way is by having this structure of directors' duties that the directors become responsible not just to the shareholders, but they become responsible to the law. So they get into trouble with the authorities in addition to getting into trouble with their shareholders if they don't respect certain things. This brings us to Chapter 2 of the Companies Act, which in Part 10 discusses the general duties of the directors. These duties have both a common law and a statutory basis. I mean, you've seen quite a lot of cases in the previous slide there that show how these things were understood and interpreted by the courts even before we had the latest impression in the 2006 Act. When you are discussing the director's duties under the statute, you are entitled, and indeed you should, look at the case law, because even though the wording may have slightly changed in the final version of the Act, the content of the duties has been around for a very long time. We can use cases that are before 2006 in order to interpret the duties that we find in the 2006 Act, and that's perfectly fine. Duties of the directors are owed to the company, both on common law power and on the power of the statute. And you see from section 170 onwards what these are. They are not owed to individual shareholders and they're not owed to employees. They are owed to the company as a whole. When somebody is complaining that the director is in breach of those duties, they would be complaining on behalf of the company. They're not complaining in their private capacity. For somebody to complain in their private capacity, then you need to go a step further. You need the directors to have engaged directly with the particular shareholder, and that interaction needs to have created a duty of care. So then the shareholder complaining that this duty of care has been breached, they have effectively like a tort-style action against the directors. This is not something that comes out of the director's duties. An example is the case of Peskin and Anderson from 2001. It gives you an explanation of the circumstances where a duty of care will arise on the facts of the case from a director to a particular shareholder. This happens, for instance, when a director takes itself to advise the shareholders about doing stuff with their money. So if a director approaches a shareholder and says, we're going to issue new shares, these shares are great, it's going to be a great opportunity for you to buy some. So they take it upon themselves to advise, and the other person goes and relies on that advice and buys those shares, and it turns out that the company goes bust like a week after. Then duty of care is created due to that communication, it's been breached, and then the loss that's been suffered, the shareholder can individually claim. Most of the time, what we're talking about here is not this. We're not talking about individual shareholders complaining about personal losses. We're talking about the directors having violated their statutory duties or their common law duties against the company. So the victim is the company. Who owes these duties? Who are the people responsible for them? Well, anybody who is appointed as a director, but also anybody who is director. It's possible that somebody operates as a director, and they're officially named in the Articles of Association as being a director of the company. But it's also possible that somebody has all the functions and all the power and all the gravitas of a director and is treated as such by everybody else in the company, even though they're not named in the memorandum, they're not named in the Articles of Association. These people are already covered in Section 251 of the Companies Act when it talks about shadow directors. Under the Companies Act, a shadow director is a person in accordance with whose instructions people are accustomed to act. If somebody acts as a boss and is treated like the boss, then it comes within this definition of being also a director of the company, even though they technically do not have the title. I mean, you can look at cases as an example, like Ultra Frame versus Fielding case from 2005 is an example of who is a shadow or otherwise known as a de facto director. If you are a director, either in the named sense or in the more general sense that people treat you as the boss of the company, then you are liable to perform those duties. If we're talking about people that are in the management chain but not directors, then things are a little bit different. I'm not talking about divisions of responsibility within the board. The board have got an executive function and some do not. We don't care about this. If you're part of the board, if you're a director, we don't care about your particular subdivision of responsibilities within the board. The entire board is responsible for complying with the duties. But if somebody is not a director, is just part of senior management, but do not hold a position in the board, then they do not become personally responsible for any breaches unless you consider them de facto or shadow directors. Because the responsibility lies with the board, and the board is responsible for all the management chain behind them. So whatever violations are done by individual managers on behalf of the company, then the board assumes the responsibility for that. So if you want an example, you can look at Canadian Aero Services versus O'Malley as a case. It's a case from 1973. It's a case where the court got the opportunity to examine whether responsibility could just lie within parts of the board or whether it could lie within parts of the management, and they took the decisions that I told you, that it's the board's responsibility in totality, so if things go wrong, the entire board can be held responsible. What sort of time frame are we talking about when we're looking into the duties? The duties are owed from the date of appointment of somebody as a director, or from the date that somebody is recognized as the boss, as I told you for shadow directors, but they do not necessarily end where the appointment ends. Some of the director's duties, things like corporate opportunities, benefits from third parties that you're not allowed to have, these are a function of a director's appointment. Also, if provisions about insolvency removes managerial responsibility for directors because directors appoint. However, they're still liable for others, still retain their duties to the company. Necessary in terms of time frame that some of the duties survive termination, because otherwise somebody could and then just quit in order to take advantage of it. This opportunity comes around, and is not allowed to do this for himself. So if it was just resigning and then running this business on their own, a lot of people would have stopped. If what you're doing, in fact, is taking advantage of a corporate opportunity, taking a bribe for a decision that you've taken while you were a director, then you will still be responsible, even though you're technically not a director at the time that you get caught. Yeah? Key expectation is that the directors have an obligation to exercise their jobs with a degree of skill, care, and diligence in the performance of their duties. This requires a little bit of explanation. This is in section 174. It says that the director of a company must exercise reasonable care, skill, and diligence, And this means the care, skill, and diligence that would be exercised by a reasonably diligent purpose with the general knowledge that one might have, but also with the specific knowledge and skills that this person has. Why is that? Because in the common law, originally, if you look at the case City Equitable Fire Insurance, then a director was only assessed on an objective standard. And they said that they did not need to have any skills or attributes in excess of what a reasonable person might have. So the common law was setting a lower level of negligence than we have today. Because if we're taking a reasonable person standard, we've come across these things before in other types of assessments, especially when we're talking about negligence. If we're trying to assess how people behave, we're saying how would one react in these circumstances, and that's your benchmark. And if your behavior falls below the reasonable person, then you're liable. If you did what a normal person would do, you're fine. But this causes trouble here because most of the directors are not only attaining these roles as a service to the company, they're doing it as a job, right? So they also have employment contracts. If you hire somebody who's legally qualified, then you would not only be expecting them to perform their work at a level comparable to the average person. You would be expecting them to understand their role and to perform their duties at a level of somebody who is actually legally qualified. If it's not enough it wouldn't be enough for a director to say, okay, I entered into this contract for the company to have internet and broadband and so on, and it turns out to be a terrible contract because the person didn't read the terms and conditions. It shouldn't be an excuse to say, oh, the terms and conditions are difficult to understand anyway. This might work for the average person, but if you're legally qualified, surely you can read the contract and understand it. So that's why the lower standard for negligence that existed in the common law is not sufficient, and it has been increased by the statute. That's why the statute has got these two levels. They're supposed to operate as a reasonable person, but if their own personal skills and attributes are higher than the average person, then they get assessed on this higher standard. So if a director is legally qualified, then you would expect them to behave as a legally qualified person, not as an average person. Hold them to a higher standard. We are not yet at the point that we consider being a director of a company as a job or as a professional function that in itself implies higher levels of skill. We don't do that, because if we did that, quite a lot of people who kind of set up their own company would run into trouble. We're not saying that you need to be a professional or have special skills to become a director. You only need to be at the average person standards. But if you happen to have extra attributes, then we would expect you to stick to those extra attributes. Now, what happens if you breach that duty? What happens if you're negligent and you're not paying attention and you take the wrong decision? Certain sections in the Companies Act have got also criminal consequences for the directors. They've got penalties, they've got stuff like that. But when the duties of the directors, we use our normal civil law standards, which means that if somebody has done something wrong, then the aim is to compensate the victim who's suffering the consequences of that wrong. This implies that in order to be able to sue the directors to compensate the company for the loss they have caused, they need to have caused some loss. If a director is violating their duties, but this violation has not had any consequence that is financially negative for the company, then there is no point in suing them and asking for damages because you cannot demonstrate any loss. I'm not saying that this violation is excused, but then it becomes an issue for the shareholders to remove the director if they think he's not acting accordingly. But the fact that somebody has done something wrong, if it doesn't have a negative financial consequence in this domain, means that there's no point in going after them. If they have breached a duty and that breach has led to a negative financial consequence, then the company, because the duties are owed to the company, therefore the victim of this loss is the company, has a right to ask that the director compensates them out of their own pocket. The fiduciary duties of the directors are based upon this, about equitable notions of duty and responsibility. And they are the sort of things that we can put broadly under three categories: that the directors need to remain within the scope of the powers which have been given to them. Yes, they have the powers to manage the company, but they have boundaries. Where are those boundaries? The Articles of Association, for instance. And it doesn't matter why these boundaries are there. It matters that they are there. So if the articles say that you cannot take purchasing decisions of a certain level without taking this decision back to the general meeting, and the director chooses to ignore this, then they're acting outside their boundaries. And then that's a violation. If they're using the company accounts to pay for their own personal shopping, they have the right to authorize transactions or use the company credit card, but if they're doing this for their own Ocado shopping, then this again, they're acting beyond their powers. That is a violation. They need to remain within the scope of their powers. They need to have good faith to promote the success of the company, and they need to exercise independent judgment. Now, what do these things mean? The duty to act within the powers is, as I said, the idea that you do what the articles say and you don't stray beyond this, and you're also respectful of what other limitations might have been put in there from the general meeting. Remember at this point the discussion that we had about effects on third parties. Third parties don't care about internal company limitations. The reason for this is Section 40 of the Companies Act. So if I'm a director and in violation of the rules of the Articles of Association, I conclude a contract with the third party still has a valid contract with the company if I was acting as a company director. But I'm still in breach of my duties because I went beyond my authority. Internal consequence and internal violation, but the contract with the third party still needs to be respected and it's valid. Remember this because this is significant. People usually mistake one for the other. An internal problem might not necessarily have external consequences in contracts with third parties. You're supposed to stay within the powers and exercise the powers only for the reasons that they're given to you. As I said, you can make transactions, but that doesn't mean that you can pay for your personal shopping. And you've got an overarching duty, which is in 172, to promote the success of the company. The statute there gives you a definition of what is the success of the company. Or rather, it doesn't give you an exact definition of what is success of the company, but it gives you a list of things to consider when you're trying to act in the interests of the company. So the success of the company is interpreted in financial terms. So you need to do stuff that are financially beneficial for the shareholders, but also you need to act in a way that ensures and promotes the company's survival and health in the future. And as you are doing this, you need to consider a number of things which include to a degree the interests of stakeholders, people that are external. This is why Section 172 is significant, because it's meant to incorporate a lot of the debate that we've got about corporate social responsibility and so on. It's meant to bring this in to the actual decision-making process of the directors. Yes, your primary purpose is to make money for the shareholders, but as you're doing this, you also need to think about external interests. You don't get sued for saying that you looked at, say, environmental concerns and you decided not to act upon it. That's fine. But you have to think about it. Low level of intervention, it doesn't mandate particular reaction from the directors, but at least it forces them to think about it, which is a step in the right direction. Duty to exercise independent judgment. This comes back to the idea that I had earlier, that you need to, as a director, you are co-responsible for everything that goes on. Meaning that if people within the board have got particular functions, I'm in charge of legal, you're in charge of financial, you're in charge of employment, right? I mean, you do need to have like a breakdown of responsibility within a larger corporation to kind of manage the workload, that's fine. But we're all equally responsible for whatever's going on. And that core responsibility is coming from Section 173. So you cannot be kind of siloed and only look at the stuff that you've been particularly tasked for, and I'm going crazy at my end. So if I'm responsible for legal and I never read any contracts and I enter into all sorts of weird transactions, it is not an excuse for you being in charge of finance or you being in charge of HR to say this was not my remit because we're all co-responsible. So if you say, I wasn't looking at it because Jan being legal, so I didn't think about this at all, you're in violation of 173 and you can get in trouble.